Why does your home, land, mineral interests trigger probate if you don't have an estate plan in place, or even if you only have a will? Let's talk about it in simple terms so everyone can understand. If you own real property, again, home, land, mineral interest, and so on. If you own real property as joint tenants with a right of survivorship with someone else, let's say your spouse, a child, or maybe a sibling, when one of you dies, the other one just gets the property. No probate is needed because it is as joint tenants with a right of survivorship. Make sure it is not tenants in common. Anyway, if one of you dies, the other one gets it, no worries there. What happens when the second person dies? Or what happens if it's just one person on the deed? Let's say you're not married. Let's say it's property you bought before marriage or property inherited. Just one person on the deed. Then what? How do you sell it? How does it work? Let's talk about it. If you are well and healthy and decide to sell that property, you go ahead and list it and you go and sign the deed and that's it. The house is sold. If you become incapacitated, meaning if you become unable to make decisions or unable to sign or unable to comprehend what's going on, because let's say you developed a mental condition like Alzheimer's, or let's say you are in a car accident, or let's say you have a terminal condition or a very serious condition, you are under heavy medication, you cannot go and sign the deed. Two things at that time. One, you either have a power of attorney that you have signed before, where you say, I appoint this person to sign on my behalf or to act on my behalf. Or your family, let's say you are in a car accident, they have to pay for your care, you're probably not going to go back home. They can sign your house by going through the court system and go in front of a judge and say, hey judge, mom, dad, grandpa, they're incapacitated, here's the medical records, allow us to become their guardians. The judge appoints someone, gives someone the legal authority to sign the deed, their name as guardian for you, and sell the house. Easy enough. Ideally, you have a power of attorney in place, so you can be the one appointing who would act on your behalf, and also to keep your family out of courts. But what happens when you die? When you die, there is the power of attorney and the guardianship terminates right then and there. And what happens then? Who has the authority to sign that deed to either sell the house or distribute it according to your wishes? If you don't have a will, you don't have an estate plan in place of any kind, someone will have to initiate probate, someone in your family, a beneficiary, and go through the court system. Again, go in front of a judge and say, hey judge, my mom, dad, grandpa, aunt, uncle, whatever the situation may be, died. Please appoint me as personal representative so I can administer their estate. The judge swears you in and signs some letters and order, and then you become personal representative. Then you become entitled to sign that deed and sell the house or give it to the kids. If you have just a will, let's say you have a will and you have an executor nominated, that person does not become automatically executor. First, they have to accept to serve, and second, they have to get sworn in front of a judge. So again, if you only have a will and you own real property, the will have to be probated. The judge has to officially appoint that executor in order for that person to have the authority to sign the deed and sell that house or distribute it to the beneficiaries. If you have a trust, that's a different story for another video. That successor trustee, without having to go through the court system, will automatically sign the deed as trustee of your trust as long as the property is in the trust. Again, watch another video on that. But that avoids going through the court system, and again, you get to appoint someone who you trust to be in charge of all this. As a quick recap, if you are alive and well, you sign the deed and you sell the house. If you are incapacitated because, let's say, you developed Alzheimer's, then you either have a power of attorney, they sign as your power of attorney, or they go through the court system, get appointed as guardians, they sign as guardians, they sell the house. When you die, they either go through the court system, will or no will, it doesn't matter. They'll go through the probate process. The judge will appoint someone officially and they can sign the deed. Or if you have a trust, that successor trustee automatically signs the deed. There are some other alternatives out there. Transfer on death deed. Sometimes people use LLCs, but that's again for another story. Be sure to watch our other educational videos for more information on that. I hope this video helped. I hope this is in simple terms why, if you own real property, it'll likely have to be probated. Please email me if you have any topics for this type of educational videos, or subscribe to our YouTube channel and maybe attend one of our in-person educational events. Thank you for watching.